Thank you, Dean Iacobucci and Professor Su. Thanks to the Dean for inviting me to give this lecture, and to the faculty as a whole for its hospitality during my 2 weeks here teaching an intensive course. I will say a little more detail about the nature of this project in a moment, but I just want to launch into the discussion directly with the observation that if I don't blather on too long, I'm happy to have questions and discussion after I've concluded my main presentation, particularly because this is an early stage of what I hope to be a more extended project. So let me frame the project. Constitutional theory dating from at least the 18th century identified 3 functions of government, each associated with what we would now call a distinctive institution, making rules to regulate and guide behavior, done by the legislature, implementing those rules, done by the executive, and resolving disagreements about the meaning and applicability of the rules, which is done by the judiciary. In this Montesquieuian framework, each branch had its own function and was to be as insulated from the other branches as possible. So I think the favorite quotation in support of this is from the Massachusetts Constitution of, I think, 1780. In the government of this Commonwealth, the legislative department shall never exercise the executive and judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them. The judicial should never exercise the legislative and executive powers, or either of them, to the end that it may be a government of laws and not of men. Now, in the late 19th and early 20th century, this hermetic separation of powers came under pressure with the development of modern administrative bureaucracies. Those bureaucracies blended lawmaking, law application, and law interpretation. And constitutional theory adapted by treating administrative bureaucracies as a 4th branch of government. I think the label probably was initially attached in the United States by James Landis. Now, we should note 2 things about this new branch. First, it didn't actually perform any functions not previously performed by the Montesquieuian branches. It was, law developing, law applying, and law interpreting, but nothing new. And second, and perhaps related, if you look at constitutions around the world, they actually rarely identify the administrative as a distinctive branch of government on a par with the Montesquieuian branches. I edited a handbook in which the author of the section on the administrative branch did a survey, and there just aren't that many express recognitions of the administrative as a separate branch. Now, for present purposes, the next development in constitutional theory, the constitutional theory of government powers, came in the 1920s with Hans Kelsen's identification of a previously overlooked function and his conceptualization of a new institution to perform that function. The function was the protection of the Constitution, and the institution was a constitutional court separate from the ordinary judiciary. Now, Kelsen's innovation spread widely over the course of the 20th century, but by the late 20th century, Constitution designers came to understand that the function of protecting the Constitution, or at least the function of protecting constitutional democracy, could be performed by other institutions, some of which were better placed than the Constitutional Court to protect specific conceptions of constitutional democracy. And I'll say a bit about some of those institutions in a moment. The Constitution of South Africa provides a convenient formulation in Chapter 9, which I've adopted for my title, Chapter 9 identifies these institutions as institutions protecting constitutional democracy. In my shorthand, I call them IPDs because IPD is easier to say than IPCDs. So I'll just be calling them IPDs. Now, this lecture is the second in a series of essays in which I explore aspects of this new branch of government. The first essay used a case study of anti-corruption investigations in South Africa and the constitutional analysis associated with those investigations as a vehicle for opening up some of the themes examined today, which therefore should be seen as offering something like a more extended conceptual and historical foundation for the larger project. I'm going to start in the next section of the talk with an examination of the reason IPDs perform a distinctive function, and then turn to constitutional and statutory antecedents to them. After that, I'll return to the Constitutional Court as an institution to discuss why supplementing a constitutional court with other IPDs might be desirable as a matter of constitutional design, and I'll also talk about the relationship between the Constitutional Court and the other IPDs. Before concluding, I'll discuss whether it's useful to think of these institutions as a new branch of government rather than as a sort of congeries of institutions with no more than a family resemblance. And then I'll wrap up by asking whether, or maybe better, how much constitutional design through the use of these institutions can actually do to preserve democracy. Okay, so what is distinctive about these institutions? I've described the Cecilian Constitutional Court as an institution designed to protect democracy. I'm now going to formulate my statements in terms of Kelson's thinking. I have come to understand that people who are scholars of Kelson's work have questions about my characterization of his thinking, and that I attributed to him actually doesn't matter much. But I just want to forestall the objection that Kelson actually didn't think what I'm about to say. I'm offering, an account of what might be said about why the Constitutional Court was a distinctive institution. Now, with that, I will start using Kelson-argued kinds of language. Believing that the British system of political constitutionalism was inadequate, either in general or under the conditions of post-World War I Europe, Kelson argued that a constitutional court was needed to ensure that democracy did not crumble when conflicts between Parliament and the executive arose. For Kelson, it was obvious that in a world with political parties, the legislature could not be trusted to respect the boundaries between the domain of legislation and the domain of execution, and in a world of political parties, that political contention could not supply the necessary constraint either. And it was equally obvious to him that the same problems affected the executive with respect to the boundaries of its power. The Kelsenian Constitutional Court then was a response to the perceived problem, as I characterize it, of conflicts of interest that might undermine democracy. Conflicts of interest among institutions, between institutions. Now, once the problem of conflict of interest is brought to the surface, we can see such conflicts well beyond the legislative executive conflict identified. The most obvious one comes with the rise of a human rights culture. There's a conflict between the government as a whole and rights holders. And Kelsenian constitutional courts, which were initially designed simply as border policing institutions between the executive and the legislature came to absorb the function of protecting human rights. These, though, there are many other conflicts of interest that threaten democratic stability. The most obvious, perhaps, involves the law of politics itself, the qualifications of parties for the ballot, determining whether an election was conducted reasonably fairly and freely, drawing district lines, and the like. And electoral commissions and courts and boundary commissions are, for this reason, fairly described as institutions protecting democracy. Anti-corruption agencies are another candidate. They protect democracy, or this is not definitional in connection with democracy, I think, but sort of an empirical truth that people have come to appreciate. Anti-corruption agencies protect democracy because pervasive corruption undermines public confidence that the government the people elect actually is worth defending. And we can't be confident that, again, in a world of political parties, legislatures or executives will investigate high-level corruption adequately. When both the legislature and the executive are controlled by the same party, everybody has an interest in sweeping corruption under the rug. And when they're controlled by different parties, the anti-corruption investigation may well be infected by partisanship. An executive will use such an investigation to take out its political enemies on either trumped-up charges of corruption or, more troublesome, by using aggressive but not unreasonable definitions of corruption to go after actions by political opponents that the executive leaves untouched when committed by its political supporters. And of course, the same is true of legislative investigations of executive corruption. Now, I have to say a bit about the best design for IPDs. It does have to respond to the problem of conflicts of interest, but it also has to take into account the role these institutions play in the ongoing functioning of constitutional democracies. The general solution, modeled on designs for selecting judges who engage in enforcing the Constitution, is to use a combination of independence and accountability, though the balance may vary from one IPD to another. And the design question is important because conflicts of interest take many forms. Here, I want to distinguish between two general categories. The first is intratemporal or contemporaneous conflicts, and second is intertemporal ones. The examples I've used so far are mostly examples of contemporaneous conflicts of interest. Today's legislature has an interest in engaging in overly aggressive investigations of executive corruption, for example. But democracy can be threatened by intertemporal conflicts of interest as well, by decisions taken today that threaten democracy in the future. And the two examples I use are, I think, quite obvious and are sometimes recognized by Constitution designers. The first is environmental protection. Ensuring that democracy will not collapse under the pressure of emergencies created by a failure to address and plan for environmental change pits today's voters against the future. We have to bear costs today that will benefit only people in the future. The second example involves central banks, whose general mission is to ensure that today's politicians don't adopt fiscally irresponsible policies today to garner public support and achieve re-election, where those policies will lead to politically destabilizing inflation in the future. That's a standard account of why we have independent central banks. Now, these intertemporal conflicts are real. The problem is that we might be able to identify so many of them, and maybe even so many contemporaneous conflicts of interest, that IPDs come to dominate ordinary policymaking. That is, if we define conflicts of interest broadly, the less than fully accountable IPDs will absorb an extremely large swath of public policy. Now, my current thinking about this difficulty, which I confess I'm quite open to reconsidering, is that good constitutional design would address it by identifying something like thresholds for the institution's jurisdiction. The thresholds would, of course, differ depending on the nature of the conflict of interest. For anti-corruption, we might limit the agency's jurisdiction to high-level corruption, hoping that political parties will find it in their own interest to eliminate street-level corruption. And there are theoretical accounts according to which authoritarian parties, the Chinese Communist Party is a classic example, do have an interest in rooting out street-level corruption while tolerating high-level corruption. Although even in such systems, the dominant or authoritarian party can use investigations of street-level corruption to weaken their political enemies and strengthen their political friends. That appears to be the experience in China, for example. For environmental protection, we might limit the agency's jurisdiction to matters closely connected to climate change, excluding protection of endangered species, for example. Now, whether the idea of jurisdictional thresholds can be developed in enough detail to prevent IPDs from taking over too much of the policy space is for me, an open question. I want to turn now to the antecedents to the modern IPDs with the aim of identifying some disadvantages with some of them. Constitutions always draw upon pre-existing forms even as they transform them. You can find many historical antecedents to IPDs. Sun Yat-sen proposed adding a control yuan, roughly an auditing bureau, and an examination yuan, roughly a civil service system, to the Montesquieuian system. And he theorized this expressly as an alternative to the Montesquieuian system. He thought these two things could not be well performed by the Montesquieuian branches. Other forms of audit courts and auditing bureaus date back again at least to the 17th century, and more recently, the Nordic nations designed ombuds offices for citizen-provoked oversight of how the laws were being administered. And those offices, too, can sit outside the Montesquieuian system. Now, I want to mention something about Sun Yat-sen's account, which I draw from a Chinese scholar writing many years ago now. It's the best I could find in the time available. According to this scholar, Sun Yat-sen was convinced that if the censorial power, which is how this author characterizes the control yuan, were in the hands of the legislature, it would be abused when the parliamentary majority was not in power in government, and purposely neglected when the parliamentary majority was in power in government. The conflict of interest that I've identified. So the Sun Yat-sen's theorization of his scheme was compatible with, or maybe a precursor of my analysis. As far as I know, though, the creation of these various institutions, audit courts and the like, did not generate, beyond this observation by Sun Yat-sen, didn't generate wider reflection on their relation to preserving democracy. They were treated simply as examples of good government innovations. again, I think I need to look into the sort of early literature on ombuds offices to confirm that. But that's my general impression. I say early literature because as the idea of Chapter 9 institutions sort of comes into visibility, you might re-theorize the ombuds offices in these kinds of conflict of interest terms. Okay, so now I've been talking about some constitutional antecedents to these institutions. Statutory antecedents to them also abound. And examining some of them brings out some important questions of design. As a first cut, I tell my students that I think in binary terms. So as a first cut, we can distinguish between ad hoc and permanent statutory institutions that perform the functions that constitutionalized IPDs do. Examples of ad hoc institutions are special counsels to investigate some defined set of events, as in the United States, commissions of inquiry into various events that have taken place. Canada and Great Britain use commissions of inquiry. And a case that I find just interesting on the facts, the commission created in the United States to resolve disputes over votes in the 1876 presidential election. I'll describe that in more detail in just a moment. These institutions are created after the event, the scandal, the police misconduct, the election itself. And that fact alone creates a problem of design. Permanent institutions are created under a veil of ignorance because no one knows precisely what events, facts, and the like they'll have to deal with. The designs have to be suitable for whatever might come up. Those who create an institution, knowing what its remit will be, will find it difficult, perhaps impossible, to refrain from thinking about how the design might influence the outcome in the case at hand. And achieving a desirable balance between independence and accountability will therefore be especially difficult. So here are some examples. Defining the terms of reference for a special counsel or a commission of inquiry. Whether the terms of reference are broad or narrow will often have predictable political consequences. A commission of inquiry with respect to some incident of police misconduct can be given a charge to investigate only that incident or to investigate what features of the police department's organization facilitated the incident, or to investigate a broad class of events of which the triggering incident was a single instance. Similarly, with a special counsel or prosecutor charged with investigating a corruption scandal. The charge might be to look into the scandal alone or into other incidents in which those implicated in the scandal might have participated, or into the conditions in the ministry that facilitated the corruption and the like. Now, political actors will evaluate the proposed terms of reference by thinking about their political implications. Corruption investigations offer obvious examples. At the outset, we will know who the target of the investigation is and what the target's political affiliations are. The target's allies will want the terms of reference to be as narrow as possible to insulate themselves from being swept up into the investigation. And the target's opponents will want the terms of reference to be as broad as possible, giving the opposite political valence to exactly the same concern. Okay, now that's that's one problem caused by not acting under the veil of ignorance. Selection of personnel to staff ad hoc institutions raises similar problems. Where we know the partisan affiliation of potential special counsels, we might ask for the United States, can a Republican special counsel be impartial when investigating a Democrat? Or, for that matter, when investigating a Republican? The problem is particularly acute where we're dealing with a single investigator, of course, and that might suggest, incidentally, that a well-designed ad hoc institution would have multi-member leadership. Multi-member ad hoc institutions have their own problems, though, and this is the story of the 1876 U.S. Election Commission. In the 1876 election, there were disputed votes in 3 states. And if the disputes were resolved consistently on partisan lines, Republicans would win. And yet, at the same time, it's not, you wouldn't think that the same kinds of problems with the vote counts occurred in each of the 3 states. There were problems in each of the states, but there's no reason to think they were the same problem, and no obvious reason to think that they were all skewed in favor of the Republicans or Democrats. So what happened, needed to investigate, you need to figure out who won the election in these 3 states. Commission was designed to achieve partisan balance in a highly charged partisan environment because the presidency turned on the outcome. What was the design? The commission had 5 Democrats and 5 Republicans appointed by Congress. They were going to divide evenly. It had 5 Supreme Court justices. 2 of them were identified with the Democratic Party. That is, everybody at the time thought of these justices as Democrats. And 2 were identified with the Republican Party. And then the 5th one was an independent in the sense that nobody knew what his political views were. He was going to be the tiebreaker. Name is David Davis. Basically, people expected that Davis's evaluation of the facts would be dispositive. Now, before the commission began its work, Davis resigned his seat on the Supreme Court to take a position as a Democratic senator from Illinois. I'll explain the politics behind that appointment in a moment. There's now a vacancy on the commission. Naturally, given the design, 5 from the House, 5 from the Senate, you were going to have to fill it with a Supreme Court justice. But Davis was the only even plausibly independent justice on the court, and the commission vacancy was filled by Joseph Bradley, identified with the Republican Party. And as everybody would have expected, Bradley voted consistently with the other Republicans on the commission, whose ultimate decision split along party lines. Now, that particular example may be too idiosyncratic to generalize, except in a way that I'll indicate in a moment. And here's the basis of the generalization. In 1876, U.S. senators were chosen by state legislatures. The Illinois legislature was controlled by Democrats. They chose Davis to be the senator. Their political calculation apparently was that he would serve on the commission, vote with the commission's Democrats out of gratitude, and then assume his Senate seat. Their political calculations backfired, of course, when he resigned before the commission met, but the generalization or the lesson of the episode then is not that personnel decisions inevitably track political alignments, but rather that political actors will try to game the selection process and thereby will undermine the institution's independence and or accountability. That is, in some sense, every personnel choice, even of nominal independence, will be viewed by partisans as potentially the product of some perhaps hidden impermissible partisan or undesirable partisan gaming. Now, having expressed all this kind of skepticism about the design of these ad hoc institutions, I do want to say, particularly in Canada, that these kinds of political influences can be constrained to some degree by norms. In Great Britain and Canada, as I understand it, strong norms dictate that commissions of inquiry should almost always be headed by retired and occasionally by sitting judges. And the initial design of the 1876 Election Commission in the US reflected a similar instinct that judges can be counted upon to be impartial to some significant extent. And yet, of course, that very same design shows that judges might not be impartial enough. 4 of the 5 justices were understood to have strong party affiliations. And in a post-legal realist world, members of the public and some lawyers will offer political descriptions, liberal or conservative, of the track record of a judge named to head a commission of inquiry. The accuracy of those descriptions may be contested, but the very fact of contention over the descriptions introduces politics into the public evaluation of the judge's appointment and performance. And here I want to pause to give what for me is the most either interesting or egregious recent example. Doesn't quite fit what I've said, but it's suggestive. So there's a judge named Sergio Moro who took charge of an anti-corruption investigation in Brazil. And the initial subject was not narrow, it was a big corruption issue, but it dealt with only one corrupting body, one corporation that was bribing people. But Moro followed the tracks where they led and greatly expanded the scope of the investigation. Eventually, the investigation led to the conviction of the leader of Brazil's Workers' Party, Luiz Inácio da Silva, and his disqualification from office. At a time, the disqualification occurred when he was the leading candidate for re-election, or for election in this past election. Lula's supporters had previously claimed, based on sort of the pattern of indictments, that Moro's investigation was biased against the Workers' Party. It was just based upon that pattern. But, and this is the move that makes things interesting, in 2018, Moro resigned his position as judge to become a minister in the government of Jair Bolsonaro. The minister in charge with investigating corruption, but nonetheless a minister in this extremely conservative government. That confirmed for Lula's supporters their initial suspicions. Okay? Again, it's not quite, this is confirmation that occurs in retrospect, whereas what I was talking about was controversy that occurs at the appointment of the investigator stage. However, so these are problems with ad hoc institutions, but they may be a sensible choice when the problems they address arise occasionally. There may be little reason to create a permanent institution whose staff sits around waiting for something to happen, or more troublingly, goes out aggressively to find problems to solve simply so that the staff has something to do. I've suggested in this work on South Africa that permanent anti-corruption agencies do have an incentive to adopt broad, sometimes troublingly broad definitions of corruption so that there's work for the staff to do. When they're created, multi-member bodies may be better than single-headed ones. Ad hoc bodies may be better than single-headed ones. And other features such as norms and the public view of judges' impartiality may not be under designers' control, though. Now, on to permanent statutory IPDs. Examples from the United States include permanent legislative and executive ethics offices created by statutes and located in the respective branches, inspectors general located within the executive departments, Examples from elsewhere include ombuds offices as originally designed. They were statutory agencies located in the legislative branch, tasked with overseeing how executive ministries administered the law at its point of application, and statutory election and boundary commissions. Now, the primary concern with respect to permanent but merely statutory institutions is of course, their independence from political control or domination. By design, they have someone they report to. Ombudspersons to the legislature, inspectors general to the department head or the president, and that person, who we should understand to be a superior officer to the institution, can control the institution's actions rather directly. Directly, for example, by removing some investigation from its jurisdiction, or by redefining the scope of its jurisdiction, or indirectly by removing the institution's head, or otherwise making life unpleasant for the head of the institution. Without constitutional guarantees, statutory IPDs are always vulnerable to political control or attack. Now again, norms can offset some of this. An anti-corruption investigator might be directed by its superior to steer clear of some potentially sensitive matter, but might invoke professional norms as a reason for doing so. And what we're experiencing in the United States is a situation where I think the anticipation of the invocation of professional norms is restricting President Trump's ability to control the investigation, the Russia investigations. Legislators might tell a boundary commission to take politics into account in a substantial way in drawing district boundaries, but the commission's members might refer to professional norms that counsel them to limit the role of not eliminate, but to limit the role of politics in drawing boundaries. Now, because these institutions are merely statutory, when push comes to shove, they might lose out. But the very fact that effectively exercising political control over a statutory IPD will be politically contentious might give the statutory institution enough independence from politics to operate reasonably well. I had a conversation last night with Professor Dawood about the Elections Canada, and I have to look into it, but the story she told me is sort of consistent with what I've just said about the vulnerability of the institutions to political challenge, but also the possibility that for a variety of reasons they might be in a position to resist or overcome the attempts to gain control over them. Okay, so now I want to turn to the Constitutional Court as the first institution protecting democracy and talk a little about its relation to the other institutions as well. So, as I said, the Cecilian Constitutional Court was the first IPD to be conceptualized as such. Meldon and Ginsburg have shown that many constitutional courts have taken into themselves some of the functions of other IPDs. They resolve election controversies, for example, or they determine ballot qualification in the way that electoral courts or independent election commissions sometimes do. Brazil's constitutional court has the exclusive power to try national legislatures for crime, including corruption, and sort of the observation here is at the moment more than half of the Brazilian legislators have been indicted for criminal activity. They are at the moment entitled to trials before the Supreme Constitutional Court, and sort of more or less everybody agrees that's a terrible, it's a terrible design. It's bad that they're all indicted, but given that they're all indicted, it's really, you're not going to get much done if you have to try these cases as original ordinary criminal trials before the Constitutional Court. Constitutional Court justices are struggling to figure out some doctrinally acceptable way to say, although the Constitution says they have exclusive jurisdiction over these kinds of criminal trials, they can figure out some way to channel some of the less significant ones for initial trials somewhere else. The trial of Lula was in a lower court under Morrow did the indictment, but that's because he wasn't a sitting legislator. He had left office. Okay, so again, constitutional courts have absorbed IPD functions into the constitutional, into themselves. The reason for this absorption, there are several. First, the one I initially thought was most important was a simple shortage of qualified personnel, perhaps especially in nations moving from authoritarianism to democracy or from severe civil strife to a reasonably peaceful order. All these institutions need people staffing them who are technically qualified and to a significant degree independent of political control. Small nations might not have enough people who have the right combination of qualities to staff a full range of these institutions. Post-transition nations might not have enough qualified people who will be generally untainted by what they did earlier. Related, the Constitutional Court might be the only institution with sufficient credibility to resolve election disputes, draw district boundaries, investigate corruption, and the like. And that might be especially true where the alternative is a completely new institution, unfamiliar to the public. So the thought is getting 5 to 9 people to staff a constitutional court might be hard enough, and once having located them, the nation's leaders might think it worthwhile just to put the matter aside and assign other IPD functions to that same group of people. Just again, a sort of footnote here, a design alternative that's used in extremely small nations is foreign judges. Bring in somebody from outside. Hong Kong and Singapore do this. They're not the right kind of nation. The Pacific Ocean nations, interestingly, use foreign judges. I think because of staffing problems. Now, having said this, so there may be reasons to layer on the other functions into the Constitutional Court, but doing that can cause obvious problems. On the most mundane level, doing other work takes time away from doing the central work of resolving disputes about the Constitution's meaning. Some IPD work may require the use of expertise that judges trained primarily as lawyers lack. The best examples that I know of involve anti-corruption investigations where you have to trace money through various hands to figure out who was corrupting whom and what the money flow was. In a similar vein, these institutions, the IPDs, might have remedial tools available to them that are more difficult for courts to use, not impossible, but more difficult. Several constitutions include their human rights commissions in their list of IPDs. I myself have to think more about whether that classification is correct, but if it is, the argument available for doing it would be that the Human Rights Commission might find it easier than a constitutional court to develop remedies for discrimination that involve ongoing oversight, supervision, and regular revision. Now, we know from Indian public law litigation and US public interest litigation, what Chuck Sable calls experimentalist litigation, that courts can do this sort of stuff, but might be easier for the other agencies to do it, easier and more effective to do it. The task of resolving election disputes and more generally supervising the law of politics implicates the Constitutional Court in what Professor Herschel has called megapolitics, and that too might cause difficulties, the most obvious one being that however the court resolves the controversy, one side will think, or at least worry, that the court wasn't impartial, or more dramatically, that the court's decision was dictated by law, not by law, but by the judge's political preferences. And that might be troublesome, not, I want to say, with respect to the particular election dispute, but because it might weaken the court's ability to secure compliance with its other orders, to the extent that that ability rests on a general sense that the court's decisions are impartial. Now, a final question here is the relation between the Constitutional Court and other of these IPDs. As far as I know, the issues have not arisen, conflicts between the courts and the IPDs haven't arisen that often. I have little doubt but that constitutional courts will routinely exercise supervisory power over other IPDs. They will police the boundaries of an IPD's jurisdiction. They will assess the procedures used by the IPDs by looking to standards they themselves develop. Now, that's not an unalloyed good, although it's inevitably going to happen, I think. I haven't explored the question here, but one important feature of IPDs is that their work entails the deployment of kinds of expertise that might not be readily available to a constitutional court. On the jurisdiction of an anti-corruption agency, for example, a constitutional court might not understand how investigators follow the breadcrumbs through straw transactions to identify people implicated in a corruption episode, even though those people seem entirely unconnected to the investigation starting point. There's an interesting provision, it's either the Constitution of either Bolivia or Ecuador, that specifically charges or gives authority to the anti-corruption investigator to look into, I forget the phrase, I couldn't find it quickly, dark money and straw transactions, fake transactions designed to conceal actual corruption. And I find the provision interesting because the Constitution drafters understood that they had to single this thing out and identify it because I think they weren't sure that anti-corruption agencies would otherwise understand that they were supposed to do this. If the anti-corruption agency can't understand it, it's not obvious that a constitutional court would. Maybe more common, an anti-corruption investigation might require, or at least find helpful, investigative procedures that might seem unfair to judges not regularly engaged in investigating corruption. In Brazil, in the Moro investigation, there was a non-standard use of plea bargaining and coercive pretrial detention that occasioned that judges, other than Moro, bridled at. And ultimately Morrow got away with most of what he was trying to do, but his departure as an anti-corruption investigator from judicial norms of perceived fairness caused jurisdictional trouble. Now, just a little summary on this. Taking the view that constitutional courts will never relinquish complete control over the operation of other of these institutions, I've suggested that elsewhere that the best solution to this problem is for constitutional courts to say, yes, we are going to supervise them, but we should give substantial deference to the jurisdictional and procedural choices made by other IPDs. I should note that in the South African case study that I've done, the Constitutional Court didn't do that. They exercised very, so we'll call it independent, non-deferential judgment about the design of the anti-corruption agency itself, with opinions that were, in the initial opinion, sharply divided, then later almost unanimous, but that were not, in my view, terribly persuasive as legal analyses. And it's reasonably clear to me that what was going on was that the Constitutional Court believed that the thing that they were looking into, and believed almost certainly correctly, that the thing they were looking into was the strategic use of anti-corruption investigations by one faction within the African National Congress against the other faction in the National Congress. And they sided with the people who are at the moment the losers, and they won, basically. The other faction displaced the prior one. But that's an indication of the kind of difficulty that actually can occur. Okay, now before concluding, I want to address a question that's concealed in the very framing of my discussion. Why think of these institutions collectively as a new branch of government? Now, part of the answer is, I think, simple nominalism. If you look around at modern constitutions, designers seem to think that these institutions have something in common and signal that belief by including a bunch of them in a separate chapter or article in the constitutions. That nominalist approach may make sense of the fact that separate identification of IPDs is a quite recent phenomenon. Again, the South African Constitution is 1995, or 4, depending on which version you take into account. Constitution designers now know or think that there's something new out there, and they've brought that novelty into the Constitution by emulation rather than deliberation. Now, I've offered a bit more than nominalism in my account of IPDs as responding to conflicts of interest between other institutions with respect to protecting democracy. Unfortunately for that functionalist approach, some institutions included in the chapters or articles that I've mentioned don't seem to respond to conflict of interest problems. Cultural preservation institutions are sometimes included in the new Latin American constitutions. They're lumped together with the other, the Electoral Commission or whatever. And it's hard to see why. Maybe we could come up with an account, but I doubt that it's motivating. So some of the things in the chapters don't seem to respond to conflict of interest problems. And as the example of central banks shows, not all conflicts of interest do or support the creation, or should support the creation of one of these institutions. In the end, I leave open the possibility that we're not dealing with something fairly described as a new branch. on the same plane as the Montesquieuian branches. Montesquieu may have been right, Sun Yat-sen may have been wrong. We may have no more than what I referred to in the introduction as a congeries of institutions that have something to do with the preservation of constitutional democracy. Some are constitutionalized in some constitutional systems, left to statutory law in others, dealt with through ad hoc mechanisms in the third group, and ignored in yet other nations. Now, I'm going to conclude by leaving the skepticism that I've just expressed on the table, but also by returning to the functionalist conflict of interest account that I have sketched. Attention to conflict of interest does help bring the function of protecting democracy into view. I think we can see a family resemblance among numerous institutions, each one responding to conflict of interest problems. At the same time, we might wonder how much actually turns on constitutional design. Perhaps, I myself think probably, institutions themselves play a relatively small role in preserving constitutional democracy. Here, my example draws on scholarship on anti-corruption efforts. That scholarship makes it reasonably clear that there is essentially no relation whatever between institutional design and substantial reductions in corruption. A seemingly well-designed institution which dramatically reduces corruption in one nation will have no effect in another, and a seemingly badly designed one which has no effect in one nation may have dramatic effects in another. The relevant scholarship converges on an alternative explanation. It's not institutional design that matters, but political leadership. That determines whether anti-corruption efforts will succeed. So a political leader who comes to office wanting to root out corruption and who finds a badly designed agency at hand is able to use that agency to root out corruption. And if somebody imports into their nation the Singaporean or Hong Kong models, which are sort of the gold standard, but doesn't want to root out corruption, then the agencies will just not do it. For other institutions, the anti-corruption example I think is a pretty good one based on existing scholarship. For other institutions, a widespread commitment to adhering to the rule of law rather than institutional design might be the key. Constitution designers and theorists can say something about institutional design, but if design doesn't matter much, maybe we should cede the domain of concern over preserving democracy to political scientists and sociologists. I myself think that wouldn't be a bad outcome. We may just not be good at, or the things that we know about may not have much to do with preserving democracy. And the things they know about may actually have to do with preserving democracy. So we might wonder whether IPDs can actually effectively protect democracy. And I'm going to end by posing that question about the first institution for protection of constitutional democracy, the Constitutional Court. Samuel Zakharov has argued that constitutional courts might be able to deploy their resources to stabilize fragile democracies, and I think by implication might be able to protect democracies from collapsing. Now, I confess that I read his book as identifying almost universally unrealized possibilities. He does identify capacities that these courts have to stabilize or preserve democracy. They might have the theoretical ability to do that, but experience strongly suggests that it almost never actually occurs. I have to say, and this is what I'll end on, that doesn't mean that constitutional courts and perhaps other IPDs don't do some valuable work. but it might be that protecting democracy isn't among the things, the valuable things they do. Okay, thank you. As I said, I'm happy to entertain questions, comments, and people telling me where I'm wrong and what other things I should look into, because this is the beginning of not the beginning, it's sort of the second version, or the second step in what is going to be a larger project, and so I am completely open to thinking about what else I should do. Yes?
To begin with, sir, a very interesting presentation. And my comment or query is that of the human factor. And the example I'm going to use, the most recent election in the Democratic Republic of Congo, where there is a constitutional court designed in terms of norms as to what you suggested in terms of representing the will, democracy, the values, the norms, all that. How do you deal with that when you're dealing with a gangster, despotic regime? And I have met with several of the judges during my time in Congo who live in absolute fear, and some are put in for the simple reason to do as they are told, and life will be good for them. Because the election in Congo, shall we say politely, was totally rigged, flawed. How do you deal with the human factor?
Yeah, I've done some work on what I call authoritarian constitutionalism. Lots of the things that we value about constitutionalism are extremely difficult to preserve in authoritarian or even dominant party systems. And so the answer may well be the only thing to do about that is to get rid of the authoritarian system. There's actually one alternative which South Africa illustrates interestingly, and Singapore in its own way does too. Excuse me. So in South Africa, as I mentioned, you have the dominant African National Congress. The ANC has won every election and is likely to win elections into the foreseeable future. But within the ANC, there are reasonably stable factions which operate within the ANC as competitive parties. And that has some consequences. So, in your I have no idea about Congo or whether it's possible, but in your kind of example, maybe the thing to do is to encourage the existence or creation of factions within the authoritarian's ruling party. Sort of footnote here, this is what I've articulated about factions within the party is, to some extent, the official theory of the Chinese Communist Party. The reality doesn't match very well because they have been, except for brief periods, intolerant of permanent factions within the party. But the theory of democratic centralism is that we can build these mechanisms into the party structure. That's all. It's not, again, maybe the answer is that constitutional design can't deal with the kinds of problems you've raised. Yeah.
Thank you so much for your lecture. It was extremely interesting, especially for me. I'm from Brazil, and I actually just spent the entirety of last year writing a paper about the Lava case. So the comments about certain oil are very well taken. My question to you is, who is going to create these IPVs? And I think Brazil might illustrate a little bit of the challenge here. Since 50% of the legislature is indicted, they don't have incentives to be the ones making the reforms, right? So there is an idea that there is going to be some kind of legislative change for these to be put in place, but if the legislators don't have the incentives to be accountable, then you create sort of a trap where the entire system is just rigged and there is no way out of it. And with that in mind, mind, I just want to add a second question, especially to hear your take about Sergio Moro. And I think the now confirmed suspicions that there were political motivations behind the way he was acting are well taken, and I'm by no means trying to defend him. But one potential interpretation of what he was trying to do was within the confines of a system that was not going to reform itself. He was stretching the law as much as he could to create accountability, considering that Brazil had not sentenced anybody for corruption since transition to democracy in the 80s, until one particular case before the Lava Jato case, which is the Mensalon case that you're probably aware of. So that's one potential interpretation of what he's doing, whether he was doing for political reasons or not. I think that's a valid separate question, right? But could that be taken as a strategy, considering that you might find yourself in a system where there is this threat and reform is not?
Yeah, so let me address both parts of your very interesting question. The first part is how do these, I actually deliberately talked about constitutional designers without talking about what incentives actual constitutional designers have when the moment of design occurs. I think the only thing I talked about relevant here was the behind the veil kind of issue. There are real problems in this, call it, rationalistic approach to constitutional design. My favorite formulation comes from Chuck Sable, writing about other related but different issues. And he says that you get this kind of design thinking occurs when everybody knows, literally everybody knows, that things are going really badly. And everybody agrees that the things that they've tried so far haven't helped. In that situation, Sable says, people might be able to step back and try to figure out what's going to work. Now, those conditions are quite stringent, and they're, even constitutional design in time zero situations, post-conflict, transition from authoritarian, there are politics associated with the constitutional design at that moment. It's not entirely a rationalistic enterprise. And I can say I have no handle on that, at least in this project. The second point is your point about Moro's expansiveness. And this is something that I say briefly in the South African piece, but will expand on as I revise it. Your account of Moro's, call it motivation, might well be correct. The problem is that he's a lawyer. And he doesn't, I will assert this as a fact, his behavior reflected a failure to understand how the kind of investigation he was pursuing was going to bring about or exacerbate the collapse of the party system in Brazil, which produces Bolsonaro. The party system in Brazil is highly fractionated and personalized and so on. And when you do an aggressive investigation in that circumstance, it's different from doing an aggressive investigation in a nation with a stable 2, 3, or 4 party system. He just, because he was a lawyer and not sensitive to politics, he just messed things up. And so just to go back to the design of these institutions, my claim is that when you're designing an anti-corruption agency, you want the head or multi-member heads actually to know something about politics. My favorite is not, well, some part of the Brazilian investigation involved payments elicited by I think it was the treasurer of the Workers' Party, that went primarily to building the Workers' Party as an institution, not to the personal benefit of the treasurer. Some of them may have done that, but mostly this was corruption. Yeah, it was corruption in the sense that the treasurer said, if you donate X to the party, I will guarantee that you will get a construction contract for an amount greater than would be awarded in a competitive bidding process. So that is corrupt. I don't, but it's not obvious that in a world where parties are as weak as they are in Brazil, it's something you should worry about. Maybe you should. Okay, that's the problem. So, okay, I'll stop with that. Anything else? Okay, well, thank you.